amendments which allowed the government to set up a fact-checking unit. Now, why is this important? Well, this fact-checking unit, and let's explain this in great detail, will identify fake or false or misleading online content connected to any aspect of the central government. Also, if this fact-checking unit identifies any information as false or fake, then social media intermediaries and telecom services providers must inform users not to host, display or upload that content. In case of violation, the intermediaries can lose the safe harbor immunity. This has led to concerns. The Internet Freedom Foundation, they will be joining us on the program as well, have said that the move will have a chilling effect on the right to free speech and expression. With this power, the fact-checking unit can issue takedown orders and bypass the checks and balances prescribed in Section 69A of the Information Technology Act. The Editors Guild has condemned this notification, saying it is disturbed by the amendment and they deeply feel that this will impact press freedom. The News Broadcasters and Digital Association today has said that this gives the government power to designate the fact-checking unit as the adjudicator of truth. Rajiv Chandrasekhar, the Minister of State for Electronics and IT, says the move is aimed solely to safeguard citizens and there are no sweeping or draconian powers. Clearly, there are concerns. There is a challenge to these amendments in the Bombay High Court as well. To take all of this forward, we're joined by N. Ram, Director of the Hindu Publishing Group and former Editor-in-Chief of the Hindu, Nikhil Pava, founder of Media Nama, and Prateek Vagre, Policy Director at Internet Freedom Foundation, also joining us. Mr. N. Ram, if I can begin with you, we have seen statements from the News Broadcasters Association, the Editors Guild as well. Give us a sense of how it threatens press freedom when you have a unit which has been set up by the government that can judge what is true, what is false, and can issue takedown orders. How dangerous is this for press freedom, according to you?
This is clearly censorship creep on censorship of the internet. That's what is being targeted, as the Internet Freedom Foundation has repeatedly made clear. I've been reading all its what it puts out, and I think it's very clear that as elections, as the 2024 Lok Sabha election nears, this censorship creep has moved forward, has advanced to dangerous limits. And I'm clear that this is unconstitutional. It violates 19(1)(a) clearly. It goes directly against the Shreya Singhal versus judgment of the Supreme Court of India. And I think they should be given short shrift. But if this is allowed, then I think news providers will also be hit, because, you know, in an earlier draft, which came out earlier, I think in February, the proposal was to include them. There was an outcry and they made a change. But, you know, news providers will be hit because they depend on social media platforms to scale up, to monetize and so on, to survive and to flourish. So this is an indirect way of hitting them as well, apart from all the rest of the actors involved in this. So this will be an outrageous, atrocious attack on free speech, freedom of the media in India. And I think we cannot allow it to pass.
All right, let's get in Prateek Vagre of the Internet Freedom Foundation. Prateek, give us a sense of the consultation process. Do you think the stakeholders, first of all, how big was this list of stakeholders who were consulted, and was the consultative period enough for a rule like this?
Yeah, no, that's a great question. I think there's a consistent pattern there when it comes to consultation, but let's just talk about this this particular one, right? Now, the initial notification for this came out on January 17th. That happened to be the deadline day of an already ongoing consultation for online gaming intermediaries. So the type of people who would be paying attention to that consultation would be, you know, people who are related to that industry. So it comes out on January 17th with a deadline of January 25th initially, right? So you effectively, to start with, had a 7-8 day consultation phase that was provided for it. Now, there was a lot of backlash. There was significant criticism. And again, on the day of the deadline, by which, you know, you would expect most people would have already submitted their comments, given how much of an impact this has for a range of stakeholders. it was then extended again subsequently till till some point in Feb, right? But the point remains that with these sort of piecemeal extensions, it made it very hard for stakeholders to engage meaningfully with the consultation process. At the time of the consultation, it was also said that there will be a subsequent meeting with stakeholders, etc. But as we saw, the Editors Guild of India in their statement have noted that it doesn't seem like any meaningful conversation or any consultation happened. So there are there's been constant concerns on that front.
Right. Concerns about not having an adequate consultation on a rule of this magnitude. Nikhil, if I can get you in at this stage, the Internet Freedom Foundation, also the News Broadcasters and the Digital Association, they have gone on to say that this bypasses the checks and balances in the IT Act. How does that do this? What kind of powers will the government get through this fact-checking unit now?
So Parikshit, I think we should be clear. What this allows the government to do is fact check, which is an irony because effectively the media is supposed to fact check the government. In this case, the government can choose to fact check, let's say, articles from the Hindu which are on social media and say that and tell social media platforms to take it down. So what that does is directly it impacts the reach of the article online. It impacts the persistence online. They can even ask Google to take it off their search links, which means that, there used to be, if a tree falls in a forest and nobody heard it, did it fall, right? So let's say if it's not visible, it doesn't exist online. So that's the power that the government gets with this. But this is just one of the many steps that the government has taken since September 2020 to reduce media freedom, especially for digital media. So firstly, in September 2020, they imposed FTI restrictions on digital media, which led to the shutting down of Huffington Post in India, which led to Yahoo News leaving India. Then they came out with the IT rules. And what those rules initially did was that they brought digital media under a registration mechanism and also brought them under the purview of Section 69A, which would allow, for example, a government committee to issue an order to any news organization to censor an article. So the direct censorship power already existed because of the IT rules. Subsequently, some news organizations like Live Law went to court and got a stay order there, which is why we're not seeing the orders. These new rules look like a mechanism to bypass that as well. Not just the Shreya single judgment, not just they're bypassing these IT rules. And I know the minister said that this is just safe harbor, that if the social media platforms don't take it down, they'll just lose safe harbor. They're not going to be that. What that means is that they could become liable for the content. And what we saw in 2013-14 before Shreya Singhal was that platforms used to willy-nilly censor content on the basis of a pure written complaint from any individual because they didn't want the liability. No platform will survive the liability and will take the risk of going against a government order. We saw what happened with Twitter, right? When they were being threatened with losing their safe harbor protections as well. So across social media, news media, there are mechanisms being put into place to
Nikhil,
platforms to censor content.
Nikhil, very quickly, if I can just add one question before going to Mr. N. Ram. Is there clarity so far with these new IT rules on the fact-checking unit, whether there is any option of appeal against an order from this FCU, any option of hearing before any content has to be taken down? What is the recourse that one has, or will one only have to go to the High Court or the Supreme Court or any sessions court for that matter?
Look, I'm not a lawyer, but my understanding is that there is no appeals process over here. But let's not forget that the IT Act itself does not allow the government to make such rules. In fact, they don't even allow the government to bring the news media under regulation. So these rules are effectively ultra-virus of the IT Act, and therefore they're unconstitutional. But what we're seeing is that since 2020, with multiple iterations of the IT rules, the government has bypassed Parliament, bypassed the IT Act. These are all illegal rules that have been allowed to get created. And we're seeing more and more, like even with the gaming part of these regulations, the government has no basis to regulate games using these IT rules. So if we keep if the courts, if Parliament keeps allowing the government to get away with creating illegal rules, this is only going to increase. What the government is now seeking to do is my understanding,
Right.
is that once the Digital India Act comes in, it will legitimize all of these rules. What we're seeing is that the rules are actually preceding the law now. So the intention of the government with what it wants with the Digital India Act is very clear if you look at all the rules that have come out along with the IT Act. And therefore, these rules are illegal.
Right. And is that the worrying part, Mr. N. Ram, the vagueness of the rules itself? Because that gives an overreaching power to the government to do whatever it needs in a situation when it feels that some content on a social media handle or on a news website is not conducive to the government view?
It's not just the vagueness that should bother us. It's the whole project. It's the whole project of the government being prosecutor and judge, as the Kunal Kamra petition, excellently drafted petition. I read it on the website of the Internet Freedom Foundation. Points out it goes against the principles of natural justice. It violates Section 79(3)(b of the Information Technology Act of 2000. It flies in the face of 19(1)(a) and also infringes Article 14. And these are the things that will surely come up in the courts. I'm glad that Kunal Kamra has promptly taken it up with an excellently drafted petition before the Bombay High Court. And I think it's a project, not just the vagueness that should bother us. A clear attempt at censorship, take down
Mr. N.
instance of the... Yeah.
Mr. Enram, do you also feel that, of course, we're seeing one challenge that has come via a petition filed by Kunal Kamra in the Bombay High Court, but the government could potentially be opening itself to extensive litigation because there will be so many people, so many. Nikhil pointed out it will further change with the Digital India Act. Do you think this new law, this new rule on a fact-checking unit is something that social media companies would like to question? Is there a precedent globally of an FCU of this kind that has been set up by any government?
There isn't, certainly not from any country that we may want to emulate. Look, and typically the trajectory with any sort of anti-disinformation or anti-fake news legislation, which may not be in the same form, but in similar form, what tends to happen is that it's weaponized, it's selectively enforced, and it's weaponized against folks in the opposition, against dissenting voices, and leading to the overall criminalization of information altogether, right? So while it's introduced in the pretext under the pretext of
I think let's not forget that social media companies in the past have also failed to challenge the earlier versions of the IT rules, which actually instituted criminal liability for one of their employees, a chief compliance officer. Also, streaming services, which were also brought under these the initial IT rules, which are also not legal, they also failed to challenge. The only entities that have actually challenged the rules are WhatsApp, because protecting privacy and end-to-end encryption was an existential situation for them, and digital news organizations like LiveLaw, which also went to court to challenge. So 2 parts of the rules have already been stayed. But I don't expect social media intermediaries to be bold enough to go and challenge the government in the courts. It's contingent on organizations like the Internet Freedom Foundation, like other news organizations, to go and challenge these rules. But the role of Parliament is also important here. These rules are bypassing Parliament. My question is, what's happening there? Why isn't the fact that the government is making rules that the laws don't allow, why aren't we seeing that being acted upon by Parliament?
Right. Possibly this is something that the Parliamentary Committee on Information Technology and Communications may take up. So let's wait and see what happens on that front and what happens in the monsoon session. We're going to take a short break, but we'll request Mr. N. Ram, Nikhil Pava, Prateek Vagre to stay on with us. This discussion continues on the other side after a short break.